making progress on that tree? That's the neighbor's job, right? Neighbor's tree?
Assistant designated.
Bottom line, you cut the tree out.
Yeah.
We don't have a signal.
Oh, nice.
And they repair the statute or part of the environment.
Oh,
He does not. He does it.
okay.
Yes, but the intent of the statute is to have those people fulfill all the rights, powers, and authority. And there's also a section of the county's code that provides the sheriff.
Oh, man.
Basically,
Yeah.
saying
Did it even end up in the pool?
that's the sheriff is all.
Didn't reach that far.
That
was good.
Because I don't want this coming back through that. I know. Down in my favor, runs up in the favor a couple years ago, so I'm just saying. I mean, there is not an exception. And I understand the intent, I get that. You're reading something in here. And if the legislature allows these guys to have designees, but it does not specifically say that these guys be designees, are you going to object to the composition of the order? It's up to you. I don't want to. I'm sure I'm going to go back and see. Okay.
Where exactly is Edgar County?
Edgar County?
You know where Terre Haute, Indiana is?
Yeah.
Right in the Indiana side.
Okay. Yeah, I go down to Terre Haute quite often.
Indiana side or Illinois side?
Illinois.
Right on the Illinois side.
I'm sorry, I had to.
Right next to, what is that,
They did not look at the substance of.
Vermillion County? Where's Terre Haute? Vermillion?
Yep, just south of Vermillion.
Yeah.
Is are one of those the board's attorney?
Yeah.
Yes. Yes.
Just making sure everybody knows what's going on. I don't think they should be talking, but that's up to you.
Dan, Dave's got other copies of stuff if you want to see anything else.
But there's no law.
And now he's simply unemployed.
In this statute, they allow the main guys to substitute people, but when it comes to the substitutes, they do not. But I don't think that's an express omission. I think that they, since it's filling those shoes, that they assume all those same rights and authorities about. this stuff over here and take over. You can do this on the fly.
Yeah. I'm good with that.
Yeah, we discussed last meeting.
We're waiting on council for the candidate.
Yeah, no, I mean, John Paul, I must have got stuck in traffic, I get it, I'm not, he'll get here eventually. Maybe he's trying to finish up his brief.
So much for civilization.
Take a left and throw something that way.
Yeah, somebody was telling me, I was in Wisconsin to Minnesota a couple weeks ago.
I feel uncomfortable.
What now? Somebody told me either in Wisconsin or backpacking up in Wisconsin or Minnesota. I got that wrong. I know, that's why I asked you, they didn't know where you went. Was it Wisconsin? Okay.
Anybody got any contact information for Munoz? Or his attorney?
I just tried to call him, he didn't answer, so I just sent that.
I'm sorry?
I said I just attempted to call him, he did not answer, so I sent him that message.
It's only been 10 minutes. Look, pick it in, you guys got it. You know what, we're attorneys. We're used to being abused, we get it.
been 15 minutes. I give them a little more time. When we start hitting the half hour, 45-minute mark, that's when we start.
Okay, okay.
Oh. If we're gonna go on.
Let's hold it up on the phone. Give me something that was on the bottom.
That's it, when you're pressing, you crumpled it up, that's one.
The dog-eared transcripts. There's a family log on it. That's pretty old. Really? You had a case with him, I remember, or is it, yeah, he was always, he never came down. Huh? Yeah. Yeah. Yes. Hi, Gianna. This is Connor McCarthy. I'm the Assistant State's Attorney assigned to the Will County Electoral Board. We have a hearing at 1 o'clock in which Mr. Ivick's supposed to participate, and he hasn't arrived. Is everything okay? auditor's office is in.
King Farm.
He was coming from court, actually.
Council ready?
Good afternoon, everybody. The County Officers Electoral Board is hereby reconvened from June 9th, 2020 pursuant to notice and in accordance with the Illinois Election Code as provided for under Illinois law to hear and pass on objections to nomination papers. My name is Lauren Staley Ferry, the Will County Clerk and Chair of the Will County Officers Electoral Board. Also present are members of the Electoral Board, Mr. Tim Brophy, Will County Treasurer, along with Mr. Brian Conzer as the representative of the Sheriff of Will County. Also present is Chief Deputy Clerk Chuck Helke and DuPage County Assistant State's Attorney Connor McCarthy, the special counsel appointed to this Electoral Board hearing. Just a reminder, there will be time for public comment at the end of this hearing, so if we could refrain from any comments or outbursts, there will be time for public comment at the end. The Electoral Board rules of procedure were previously adopted, and those will govern all of the Electoral Board proceedings. We will go ahead and sign those rules now, as we did not previously due to some distraction during that hearing. And-
Next page.
I know. Yep. This page is bent. Just one original, yeah. Sorry, you guys. There you go. Legal counsel, will you please commence the proceedings on behalf of the board?
The matter before the board is case number 2020-1 entitled Girat v. Munoz, Richard Girat objector and Richard Munoz candidate for the office of Will County State's Attorney to be voted on at the November 3rd, 2020 general election. The objector has filed his objection and supporting documentation. Candidate has filed a motion to disqualify Clerk Staley Ferry from sitting on the Electoral Board. The board has heard some argument at its last meeting and has reviewed the pleadings and the transcripts. The parties can now argue their respective legal positions on all the issues raised in that motion to disqualify. The candidate will present any arguments he wishes in support of the contention that Will County Clerk Lauren Staley Ferry has developed a pre-existing bias with regards to the objector or candidate. The objector will have an opportunity thereafter to present any arguments in opposition to the motion to disqualify. The candidate will then have an opportunity to reply to those arguments. Mr. Ivan?
Thank you. Mr. Piles, board members of the board, if I may briefly. Both the Will County Republican Committee and Mr. Munoz are entitled to a disinterested and impartial board to make this decision. Mr. Piles had argued in his response that this is a purely legal matter that you guys are to decide. That may be true. Nevertheless, they're entitled that the decision maker doesn't have any preconceived notions or bias or interest. As set forth in our petition, or our motion to disqualify, we believe due to the unusual circumstances that Ms. Ferry should disqualify herself. Namely, prior to even a petition being filed, she took it upon herself to investigate this. She sought a special prosecutor to represent her at the actual filing. You were there personally, and while there's nothing wrong with the clerk doing the job herself, it is relevant that how you treated Mr. Munoz's filing is different from the 318 other filings that you took. I believe if we were to call you as a witness, that you didn't spend 20 minutes on each of those personally. It is that investigative act that you were taking ahead of time which disqualifies you. It is improper to be both the fact finder and the prosecutor, or the fact finder and the witness. The law is clear that it's not the role of the clerk to lead her own private investigations. It's your role to be part of this board and to fairly hear. The case law cited by my opposing counsel is a Rule 23 case, which specifically states that it's not to be cited as precedent. It is distinguishable from our facts. It deals with the primary. It deals with a candidate who is not being nominated by a major party. We are not under 743. We are under 761. When there is a vacancy for a major party candidate and none was run in the primary, they have the right to select a candidate. That candidate has to get the nominating signatures. They file that with the clerk. Unfortunately, the clerk took it upon herself to actively investigate this, to show more interest than is warranted. And again, it's that hint, that's a of bias. If you're expecting to see something, you're going to see it. An example, I have a good friend who's a biology teacher. He teaches his kids that if you expect something in science, it's a bad thing. It's very important that you have an open mind, that you don't come into something already expecting a result. He then takes out what appears to be a candle, puts it on the counter, clicks it and lights it, lets it burn for a few seconds, covers it up, and lets it go up. He tells all his kids, okay, not what you expect to see, write down exactly what you saw. He collects the papers. Every single one of those students talk about wax melting down the candle. Unfortunately, the day before, he cut a potato into the shape of a candle. He used an almond sliver because it has oil as the wick. And so all these kids, they thought they saw a candle, and so they, of course, saw wax. Again, you were looking for a reason to kick my client off the board. You can't be both the investigator, the prosecutor, and the fact finder. And again, I think the case law is clear. You should recuse yourself so that we don't have to do this again. And I'm going to ask you to respectfully recuse yourself, have another board member go in front of the judge to ask for the reappointment of a disinterested person. Thank you.
Mr. Piles?
Thank you. Members of the board, council, I filed a brief in response to this. My argument was relatively simple, that I think that there might be a little bit of witness testimony from Mr. Munoz, but at the core, this issue is a legal one. And it's whether or not a candidate who's been slated by an established political party can they file a statement of candidacy for that established party when they voted the other party in the preceding primary. It's a legal issue. I think the board has got to hear arguments on that and take advice of counsel and then make a decision on the election code. The case cited by Mr. Ivick in his motion is a case that I argued all the way to the Illinois Supreme Court. So I consider myself very knowledgeable about the rules of when somebody should and shouldn't be recused. In the Giroux case, the clerk was present at the filing, and the objection was what was the condition of the petitions at the time they were presented to the clerk. And it was the clerk who was on the board that actually took the petitions, and she was in fact going to be a fact witness in the case. She remained on the board and made judgments regarding her own credibility as a witness, and the Illinois Supreme Court said that that violated due process and sent the case back. So that's not the factual circumstances here. Factual circumstances are here is there is an issue regarding the eligibility of a candidate. It's a legal issue. Now, the Illinois statutes are very clear who serves on this board. It is the county clerk or designee, it is the state's attorney or his designee, and it is the circuit clerk and or her designee. And there are substitutes provided in there for the sheriff and for the treasurer to take place in case a board member has to recuse. Now, in that statute, the legislature made a value judgment that a county clerk whose office accepts the petitions, accepts the objections, and they place the clerk on that board by statute. Now, Mr. Ivick is presenting a situation, and here in Will County, where we have nearly 1 million residents, and the clerk's office has literally dozens of employees, that's one example. But in the greater part of Illinois, a county clerk's office may have 1 or 2 employees, and the clerk personally would take the petitions in all of the races in most other counties in Illinois. And that they would have actual knowledge of whether or not, the petitions were filed and so forth. So to make a statement that the clerk personally took this, that somehow that disqualifies her, I think that that is contrary to the legislative intent of the statute, where the clerk is to be on the board. Now, they talk about there's an investigation. And in the world of the Republican chairman and the candidate, there's a conspiracy around every corner. There must be something going on. And the problem is that because of that, the sight of a public official doing the job seems foreign to them and unknowing, and they're unfamiliar with it. And in this particular case, the clerk, under statute 10-8, the clerk has a duty to make sure that the petitions are in apparent conformity with the election code. Now, there are some unusual circumstances to this particular petition filing, and I don't think that the clerk in this case, at least the circumstances, would suggest that there was any investigation being conducted, because number one, the petition contained not 1 but 3 candidates. Number 2, there was also a resolution attached to that document, and then there were dozens of signature pages, numbering, and other issues that were involved. Now, I understand the affiant said an affidavit, and he gives testimony that every time he's been in the clerk's office, it only takes a minute or 2. And it's good for the affiant, Mr. Ronkowski, to have envisioned an efficient clerk from time to time, but I think there are other people who would give contrary testimony that sometimes it takes several minutes to get through maybe a document that only has a couple of pages to it, for whatever reason. And the problem is that under the case law, they have to present a little bit more of, well, we think, or it might be, in order to show bias on the part of a board member. Girat, again, my case that he cited, talks about this in very great length. And within Girat, there is a case called Hortonville that is cited that states very plainly that the mere knowledge of an agency member, in this case the clerk, having knowledge of some of the facts that occurred, that does not require her recusal from the board. Again, it goes back to the question, if the legislature thought that, well, just because the clerk's office is taking the petitions, why would they name her to the board anyway? Obviously, the legislature in this case has the clerk on there. The clerk is the chair of the board, and it's going to, and I think it's presumed from what the statute says that the clerk is going to have knowledge of the petitions that are filed within her office. Now, Mr. Ronkowski put some photographs in this motion, and I guess it's great to see pictures of people, at a booth, and looking at papers, but I don't know what the photographs show. Seems to me the clerk's office was being extremely efficient and having enough people there to go through the petitions to get the folks in and out and get it filed. Now, all this belabored argument that I'm making, also, we need to realize one fact. And the fact is this. If there was a problem with the petition, and I didn't quite follow the biology example given by counsel, that if you're looking for something, you're going to find it, well, his example does not come into play here. Because if she was looking for something to reject the filing, which in our position should have been rejected based on the Deutsch case, which is attached, I don't cite it as president, but I cite it for context within the transcript that was attached to counsel's motion. If you look at that case and the circumstances there, the clerk rejected the filing. There was an impediment. And despite the arguments made, this is a very same type of situation. a person voted one way in the primary or filed a statement of candidacy for another party and then attempted to run either as a member of the established party or as an independent. The statute reads the same way for all the circumstances. It means the same thing. Despite all of that, the clerk accepted the filing, and here we are. So if the clerk was supposedly doing an investigation, the clerk didn't find anything because she accepted the filing and allowed the objection process to go. So I'm not quite sure where they think that this grand conspiracy is, given light of Will County's experience with people voting one way in a primary and the Republicans, and this is the second time this has happened within the past 2 years, where the Republicans are raiding the Democratic Party for candidates to run it for vacancies. So, again, and this board was involved in that objection. It was Christian Carey in 2018, voted in the Democratic primary. Republicans put him on as a Republican candidate. And wonderful, wonderful world we live in, where we can party raid and party switch within an election cycle, contrary to the Illinois Election Code. I want to respond to one other argument made by Mr. Ivick. There's a lot of confusion by the candidate in this case. He seems to think that because this is just a vacancy, that we get to throw out the other sections of Article 7. They don't apply. There are 3 steps that are involved. Number 1, if you have a vacancy on the ballot, the established party has to hold a meeting and there has to be a resolution filed evidencing that meeting. That means there has to be action by the party to put a candidate on. Number 2, they have to file petitions with signatures of voters in order to show that the candidate that they've slated has the requisite political support to be on the ballot. And on that petition, there's also statements that the candidates that they've slated are members of their Republican Party. So that's the second action that's required. First the party, then the voters have to take an action. And then, third, and again, another individual part, is the candidate has to sign a sworn statement of candidacy that indicates that he is a qualified voter of that party and that he is running for this slot. So there are 3 things that have to be done. Now, if you look at 7-43, I don't see any exceptions for that statute not applying in the event that there's a vacancy. I didn't read that in there. And maybe I'm going to get educated. It's in a paragraph somewhere where it belongs. I don't recall reading that. I have a copy of it here. There is no exception. What does the statute say? The statute says you may not file. It's not a, you may not file except if you're slated by an established party. It doesn't say that. It says that the candidate cannot file a statement of candidacy if they either file a statement of candidacy for a different party for the primary, or they voted and declared themselves a member of that party in the primary by pulling a ballot. 7-43 talks about that's qualifications of voters at the primary. Now, I have attached exhibits here. It seems that Mr. Munoz did vote in the primary. So that section of the statute applies to him. What did Mr. Munoz do? And again, going back to the legal issue, not requiring recusal by the clerk. He pulled a Democratic primary ballot. What does 7-43 say? In order for you to vote in a primary, you have to declare your party affiliation. In that primary, he declared his party affiliation to be a Democrat. What does the statute go on to say? Once you do that act, you may not file a statement of candidacy for the general election for a different established political party or as an independent. Now, I guess in the world of the candidate and the Republican chairman, Well, that can apply to all sorts of circumstances. Unfortunately, under Article 7, and by the way, all the papers filed by the candidate were pursuant to Article 7 of the Election Code. So we can't argue that, well, you're talking about a different article of the code. No. The making of nominations by political parties, Article 7. And in Article 7 is 7-43. And 7-43 says you may not file a statement of candidacy for an established party if you voted for a different party in the primary. It's a legal issue. The only factual thing is I've got to put the candidate up on the stand and flesh this out. And then we got to make a determination on what the law is. There is no testimony calling the witness of the clerk and say, what were you investigating and what was this motion? Not relevant to the objection that's been filed by me, by my client in this case. Solely a legal issue going to that statute and whether it applies or not. There is no valid basis in their motion under Girat or Hortonville or any other case that talks about conflicts that says that the clerk has the obligation to recuse her. Because frankly, by statute, the clerk is supposed to be on this board and is expected to serve unless there's a clear showing of some bias. Not some alleged scheme or conspiracy, but they actually got to put something in. And the only real thing that put in the motion was the affidavit by Mr. Ronkowski, and he says, well, you know, it took longer than my experience showed, and here's some pictures of the people that were staying around. Well, that doesn't amount to anything, ladies and gentlemen. Nothing. This is purely a legal issue. There's no reason for the clerk to recuse. Candidate can run and go do anything he wants, thinking he's going to win that. And I'll have my Girat case and all the citations that are contained therein to back up my position that indicates there is no grounds for the clerk to recuse herself from this board and for her not to do her statutorily appointed duty. Thank you.
Mr. Driver, reply.
Thank you. Counsel, I agree with Mr. Piles that this is a legal issue, but all of his argument of whether or not what law applies will be at another date. The issue before this board right now is whether it's appropriate for one of its members to remain on it. He is correct. There's about 1 million residents in Will County. And this petition is seeking to disenfranchise, to eliminate all choices. I think that the part of disagreement is what's the standard of recusal. Again, I think Girard stands for the fact that the party, the candidate, has the right to an impartial fact finder. If the fact finder has a pre-existing bias or a pre-existing interest or unusual interest, the only right thing to do, to protect the integrity of the process, especially with the stakes involved, is to recuse herself. The council, argued that the clerk was merely doing her job, and that's where you become a witness as well. If you treated this case any different from the 318 other filings, that's important. That shows bias. That shows an interest. Unrebutted is the affidavit by Mr. Ronkowski. They could have filed a counter affidavit. If they had other experts or other people very familiar with the process, they could have. His affidavit stands unrebutted, and this is an attorney who has witnessed filings for over 42 years. He's not 42 years old. He's practiced election law over 42 years. And his affidavit says that I offer the following observation of extreme and unprecedented interest in the Will County Clerk around the filing of the Will County Republican Committee slate on June 1st, as individually and collectively being unprecedented in any other filings I've witnessed over the course of 42 years. He then states that it took approximately 20 minutes when it says, normally I see it taking no more than 2 minutes. So, what we have here is prior to the petition being filed, the clerk was looking for a way to keep the ballot off, to keep the candidate off. She went in front of Judge Shainstead and had a secret hearing. It was closed until Mr. Munoz came in with a motion to have it open. It is interesting that in the transcript of that hearing, your grounds of potentially not accepting the petition are the exact same grounds that were filed 3 days later by this objector. I don't know if there's coordination between the clerk and the objector, but what I do know is that the clerk was acting as a prosecutor, as an investigator. It can't be on both sides. That's not right. If a judge knew about a case before, Judge Rudman is a judge we all know. He used to be a DUI judge in this very courthouse. He was driving back here and got hit by a drunk driver. He stopped the guy. He wasn't letting that guy go anywhere until the police came. Now, if Judge Rudman, when the person came in front of him, says, well, I'm impartial, I didn't prejudge it, that'd be ludicrous. That would defy reason. When the clerk is investigating this ahead of time, when the clerk is taking 20 minutes for something that should take 2 minutes, when the clerk is always already looking for a way to keep my client off the ballot. The issue isn't the legal part of it. The issue is whether or not the process deserves to be fair. And so for those reasons, we respectfully ask that you recuse yourself, or that the board's vote to have you recused, and one of the members requests the judge appoint. There is a process. There is a process that if there's a conflict, that the judge can appoint a third party. And that's the process that should be done here today. Thank you.
Thank you, Mr. Ryder. Madam Chair, the parties have presented their legal positions on this motion.
Assistant State's Attorney McCarthy, could you please provide the Electoral Board with your legal opinion on the issue?
Sure. In a motion to disqualify, the burden of proof or persuasion is on the movement. In this instance, the county clerk is presumed to be qualified to serve upon the Electoral Board, barring introduction of facts that indicate dishonesty, personal interest, or other serious bias. To prove bias, the candidate must overcome a presumption of honesty by showing in the record that the administrative proceedings were either tainted by dishonesty or, and I'll emphasize this, contained an unacceptable risk of bias. The candidate's motion is accompanied by an affidavit. The affidavit purports to contain allegations of bias by the county clerk in the acceptance of the candidate's nomination papers based upon the affiant's personal observations and past observations of processing nomination papers. To the extent that the candidate has shown any bias or any risk of bias, he fails to do so beyond the level of potential bias which the statute necessarily implies. The statutory duties of the county clerk require her office, in this case, to participate in the acceptance of nominating papers. As part of that acceptance, the law is clear. The clerk must review such nominating papers for apparent conformity with the statute. That's section 10-8 and 10-15 of the election code. In performing her duties as a, quote, gatekeeper to turn away nominating papers that do not even purport to conform to the law, and that's a quote from Samuelson versus Cook County Officers Electoral Board, citing North versus Hinkle, a 1998 Second Appellate Court District case. The best the affidavit can claim to allege is that the clerk obtained some familiarity with the facts underlying this matter. It's well established by Gerard v. Keith that such familiarity does not disqualify a decision maker. Such familiarity does not establish a sufficient risk of bias envisioned to disqualify the clerk from sitting upon the electoral board. So that would be my opinion on the matter.
Based on the arguments made by the parties, I will entertain a motion to either grant or deny the motion to disqualify the Will County Clerk from serving on the Will County Officers Electoral Board. I will not vote or participate in these deliberations.
I move to deny the motion.
I'll second the motion to deny.
A motion has been made and seconded. Is there any discussion from the board members regarding the motion?
What was the date of the hearing with Judge Shanestead?
June 1st.
Thank you.
Any other discussion? All in favor of the motion, say aye.
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 Any opposed, say nay. The motion carries. That concludes the ruling on the motion to disqualify. Based upon that ruling, the board is prepared to move forward the objection. Would counsel for the candidate like time to prepare a written response?
I have a motion that I'll be filing today for emergency petition for judicial review. If you want to set this for a hearing for next week, and then if the judge grants the motion, then obviously we'll be back, so.
Mr. Ivan, may I make a suggestion that we give you the leave to file some sort of response if you wish? We can set out whatever.
Oh, I have my petition right now.
Oh, I mean, just if you wanted to file a response to the objection in the interim.
A response to the objection?
Yeah, if you wanted to.
No, in response to our ruling.
Yeah, I'm not going to file a separate response to the ruling. I'm going to file a motion for emergency judicial review.
I just wanted to try and offer you an opportunity if you wanted to file a written response to the objection while that's pending. Just because, as you know, these are expedited matters. There's time for ballots to be printed and other deadlines. So I wanted to make it clear that I would suggest that if you wanted to take the opportunity to, while you're filing your motion for review, also get a written objection on file, that would help move the process along.
Well, I'll consider that. If I decide to do that, I'll give everyone proper notice. I do have my notice to give you guys.
I'll accept it.
Original has all the exhibits in the packet twice.
Thank you, Council.
May I address the board quickly on another matter? The Illinois Election Code is very specific about who is supposed to be members of the board. On 10-9, as I argued before on the other, it's the county clerk or designate, it is the circuit clerk or designate, and it's the state's attorney or designate. If there's a conflict, it provides for the statute to specifically say, and I want to quote directly, from 10-9. My concern is, and I certainly don't have a problem with the gentleman from the sheriff's office being here. The difficulty that I have is the election code does not specifically allow the sheriff to designate somebody to serve. And I'm going to quote the language. So in section 2, when it talks about the county officer's electoral board, the statute very clearly says, shall be composed of a county clerk, comma, or an assistant designated by the county clerk, comma, the state's attorney of the county or an assistant state's attorney designated by the state's attorney, and clerk of the circuit court or an assistant designated by the clerk of the court shall of the county. So they're very specific in the statute about who the board is supposed to be. When it relates to the substitutions, however, it reads, in the event that any member of the appropriate board for relation to the objector's petition is filed shall not be eligible to serve and shall not act as a member of this board, and his place shall be filled as follows. And then A, in the county's officers electoral board by the county treasurer, and Mr. Brophy is serving in place of either the state's attorney. The circuit clerk is also recused because she is in the petitions. And then if he or she is ineligible, served by the sheriff of the county. Now, the statute is very specific in one section where it allows the main members of the board to be designated, to allow somebody to be designated in their place. It does not give that option to a substitute. So I think council and I agree that we want to have as clean of a board and a hearing as we can have, and I I mean, I have a concern here because the statute does not allow, and I know who the sheriff is, it's Mike Kelly, I know who he is. He is not sitting here. The statute says the sheriff of the county shall serve as substitute. It doesn't say sheriff of the county and/or his designate. I want this to be clean, and I want to make sure that we have a properly constituted board. So I bring that before the board, I cite the statute, and so I guess to said, I object to the substitute for the sheriff because the statute does not specifically provide for it.
Mr. McCurry?
I'd like to respond, Mr. Piles, and I will point out that the intent of the statute is that the individuals named as substitute step into the full power and authority the individuals are substituting for. Anything that those individuals can do, the people that substitute for them can also do, which would necessarily imply a designee. But I will also point out specifically as to the sheriff, and I understand most council in this are experts in the election code, but I would direct you to the county's code, which is section 55 ILCS 5/3-6015, powers of deputies as pertains to deputy sheriffs. Deputy sheriffs, duly appointed and qualified, may perform any and all the duties of the sheriff in the name of the sheriff, and the acts of such deputies shall be held to be the acts of the sheriff. I am sensitive to your concerns about the interpretation of the election code standing alone, but as council know, we don't interpret the code standing alone. The law must be read as a body. And I think in specific case here as to the powers of a deputy, that where that power is implied in the election code, as I said, it steps into the shoes, the specific authority designating that deputy sheriffs may perform any and all of the duties of the sheriff allows the deputy sheriff, in this case the undersheriff, to serve in this capacity for the sheriff. And that's my opinion as counsel for the board.
Can I just,
Sure, Mr.
again, and I don't want to be difficult here, but the statute has the same language for the state's attorney and the assistant state's attorneys. It has the same language for the county clerk and the deputy clerks. It has the same language for the circuit clerk and the deputy circuit clerks. That language that you talk about in the county's code, that applies to all of them. I mean, if the deputy clerk takes the petition in the name of the county clerk, right, and that's what that statute talks about. That language that you say for the sheriff, that's available for all of the county officers. Problem is, again, to go back to the election code, it is very specific when it allows a designee for the main board members, but it does not allow a difference for the county treasurer and the county sheriff. I understand what you're saying about the full power and authority, but that language is in the clerk's code, it's in for the state's attorney, and it's in for the circuit clerk. Their deputies have the same powers as the office holder. But in the election code that we're talking about, the Constitution and Election Board of the Electoral Board, there is an exception to allow the designees for the 3 designated primary board members, but it does not allow a designee for the treasurer and for the sheriff. And I appreciate your argument, but again, that we're going to look at what the statute says, and what you say is true for the sheriff, but that applies to all the office holders, and the legislature has made an exception for the 3 board members, but it did not do it for the treasurer and the sheriff. So that argument presents a problem to me. And if we look at that, and and again, you look at Jurat, I'm sorry, the courts are going to, if you've got an improperly constituted board, doesn't matter what the underlying case is, we're going to be back here. So, I mean, I hope it's not too much of a problem for the sheriff to personally sit on the board. That solves the problem. And then we don't have an issue and we can move on and get this done. I don't want this, you agree with my interpretation of this, do you not?
If I can
Sure.
speak for myself.
Sure.
Mr. Piles and I do agree with the legal interpretation. It's ironic that you have a petitioner and a respondent both before this board, both think the board is improperly constituted. Mr. Piles believes that the sheriff needs to be there because of the way that this is specific in the statute, and I agree with him. We believe that not only the sheriff, but also the clerk, because of her interest and her bias, shouldn't be there. And what we have now, if you agree with Mr. Piles, and you agree with me, is that we have the sheriff's designee improperly voting on the petition whether or not to recuse the clerk. We're already a mess. Again, it's a mess. And just like Mr. Gerard is entitled to a fair board, he's entitled that this board is impartial, that it's constituted according to statute. I agree with that. And I think that having voted on my motion invalidates that vote. And so I don't know if the board wants to consider this and maybe do another motion to, hey, maybe we should come back and do this again. That probably would be proper. Or I filed my motion. I assume Mr. Powell, since he has the right, he wouldn't just say it just to say it. I'm sure his client wants a fair board. He could file his motion for Mr. Rickman as well.
We're going to corner here, and this is being taped. I'm satisfied with the record. If Mr. Ivik doesn't have an objection
So I have an objection.
to the sheriff,
Objection to
well,
both.
Okay, then,
Mr. Ivik, I have not had a chance to review in detail the emergency motion you just handed me. Is that objection reflected in this motion?
Not on the sheriff.
Is it your intent to file an objection with regards to this, with regards to the sheriff?
I presume that Mr. Pyle, since he made it, is going to follow through and not just waive things that don't mean anything.
I am not going to go to the court to substitute for the judgment of the, I don't think that an emergency judicial review thing is going to go anywhere anyway. I mean, people can file whatever they want. I'm just making my objection for the record. I think that there's a problem here.
I agree.
If both the objector and the candidate have a problem with a sheriff designee saying, I think that we're both asking that, the board consider that and maybe having the sheriff here. And I also agree with another thing that Mr. Ivik said. Because the sheriff is not here and he's not participating in the vote, well, that throws into question the validity of a motion for the clerk to recuse. I don't agree with the clerk. Obviously, I've spent a half hour talking about it. But as I don't think that they've met the burden that they have to ask the clerk to recuse. The problem that I've got, and I think Mr. Ivik has, is the statute is very clear on who's supposed to be on this board. And I want the board to be constituted, that's in the election code. Mr. Ivik wants that too. I don't want this to be an issue later on. So I guess I'm making my objection. I'm not going to run off and file things. I have confidence in the board. I brought this to the board's attention, and I would think that maybe the board should take a moment to consider the arguments that have been made. And
Well, it sounds like this might get brought up in the emergency petition anyway now, based on Mr. Ivik's conversation.
I don't think the emergency motion is going to go anywhere. So I'm just saying, and I'm not joining in whatever he's doing. I don't even think it's well taken. I think the board's got to make a decision. I think if he's worried about this, he needs to take that up on a judicial review after the board has issued a decision. I don't know, and I'm not sure what the process this emergency motion doesn't even exist under the election code. The board has not issued a decision yet. Can't file a petition for judicial review until there's been a written board decision made. That hasn't happened here. So I don't think this is going to go anywhere. I just ask that the board maybe take into consideration what I brought up about with regard to the sheriff. And again, I don't have a personal problem, and I don't know who the designate is. I'm just going by what's in the election code. That's what the statute says. I think we need to follow what's in the code.
Well, the board's heard my opinion on the matter. The board's heard the opinion of both counsel. I'm outnumbered, apparently. But it's up to the board's discretion to determine if you think you're properly constituted with the sheriff's designee. As I said, I think that counsel and I differ, obviously, on the intent of the legislature. The legislature grants these broad powers to act on behalf of certain county authorities. It's important that you read that into what they've written. It's presumed that they understand what the other law says when they write other parts of the law. There is no case law on this, in case anyone's curious. I'm sure Mr. Piles has probably looked. I'm sure Mr. Ivick has looked. I've looked. There's no case law on this matter. So it's up to the board to determine whether they believe they're properly constituted based upon the statutory authority of the election code and also the powers of deputies under the county's code. If the board wants to take that under advisement, set this matter for evidentiary hearing, that'll give time for a ruling on the emergency motion, which Mr. Ivick has indicated he intends to file.
Well, here's the thing. If the board goes back and makes a decision that maybe the sheriff needs to be here, that's gonna make his thing moot, because then the board is gonna be reconstituted, and we're gonna have to do the recusal thing again, because we're gonna have, because it was a 2-0 vote, and if there's a person that's taking a vote that could make a difference, that's gonna be an issue. So, again, my suggestion would be that the board take a minute, consider what's been said, and if they agree with what the council has said, and the sheriff needs to be here, we set a new date for that, then we'll do the recusal thing again, and then maybe that'll make
this decision.
well, the ruling,
To be clear, Mr. Ivick, it's not a decision until it's a written final decision of the board, but it's a ruling on the motion. It's up to the board if the board wants to confer and determine if they want to reconstitute with the sheriff present. The board does have the authority to do that if it wants to. In that case, I agree, we probably would have to go and have another ruling on the motion to disqualify the clerk. Like I said, there's two opposing positions here. There's case law on both sides, there's statute on both sides of it. Ultimately, it's the board's decision, so it's up to the board.
Madam Chair, I have sincere concerns given the comments made here today and would like to suggest that we recess for another date and consider, is it proper to recess or to adjourn this board and reconstitute a new electoral board?
Let's go with recess because the board needs to be convened, but we would recess and reconstitute with the sheriff physically present.
Okay. My motion then is to recess until we can do that.
Is there a second for that motion?
Second.
Okay, I guess, Madam Clerk, if you want to call for the vote. I shouldn't take over the chair's role, I apologize.
Oh, sorry. Go ahead and call them.
Point of order, Chair, before you recess, do we have public comment?
Public comment at the end,
Public comment will
please.
come at the end, sir. But again,
Please.
it's important that the record be clear. If you could please just hold public comments till the end when you have the opportunity.
Please,
We're
at the
making a
end.
motion to recess, then it's over. Then we're gone, we're done for today.
No, until the board orders itself to be recessed. The motion can go first, then we can have public comment, then the chair can hold the meeting in recess.
Okay.
I believe you were at the point where there was a motion and a second.
And a second, yeah, and we'll go ahead and call the roll.
Treasurer Brophy,
Aye.
Clerk Lawrence David Ferry,
Aye.
Brian Concert, aye.
Motion carries. Okay.
just so we're clear, so the board is gonna reconstitute.
It appears the board is desired to reconstitute.
Okay, so your thing is at least in advance until there's a new thing, right? I assume so.
So now there's public comment, Madam Chair.
Now the question is when do we come back?
Mr. Piles, hold on, Madam Chair has a motion, there's public comment.
Do we need to set any briefing schedules or?
I don't believe we need to set a
Timeline.
briefing schedule right now. I think it's time for public comment, then we can adjourn the meeting.
Okay. Does anybody have any public comment?
Mr. Pratt.
My name's Mr. Allen.
Oh, Mr. Allen, I'm sorry.
Kirk Allen, Kirkallen. Mr. Pyle, I appreciate your argument. We wrote about this the other day. I appreciate the decision that you've made in relation to the advice you were given, and we look at statutes in its whole. First and foremost, plain reading of the language within the specific statute. The county code that your council outlined, that falls within all the sheriff's duties in the county code. The specific language in the election code, since it was silent on the issue of the sheriff, it is a prohibition based on statutory construction because there is no reference for that. Had the legislator intended for that position to be filled by a deputy, it would have said so. That's the plain reading language that has to be applied before you jump into other statutes to make loopholes to make it okay. I appreciate you doing the right thing. Thank you.
Anyone else, public comment?
John Kraft, KRFT. When you reconstitute or schedule more meetings, can you let security know? So we don't have to keep asking permission to bring cameras and cell phones. And also let them know that anybody that comes to their door and says they're coming to this meeting should be allowed in with their cell phone. Just not just media, but any person of the public can come in here with their phones and record if they want to. That's all I have to say.
Thank you. Anyone else with public comment? Seeing none?
Council, when would you like to come back?
That's available Monday morning.
Do we have to check on the availability of the sheriff?
We probably should make sure he can be here,
Yes.
if you wouldn't mind.
Why don't we give it a little time then?
We'll have to do another call. We'll have to do another meeting call, but yeah. I'm available any day but Tuesday.
Madam, or, 17th in the afternoon is good with Mr. Ivan and myself, if that's okay.
Is that Wednesday?
Yes.
Wednesday the 17th,
It's amenable to me.
Is that good?
What time?
1:30?
1:30?
Is that where you were like today?
Oh, I thought it was 1:30.
That was 1 o'clock.
Did you?
Was it 1 o'clock?
Yes.
Yeah, we're all sitting there waiting for you.
I apologize. Well, court's normally at 1:30.
That works.
Got my suit.
If you're gonna reconstitute the board, can you put the rules on the agenda and adopt them properly, please?
Respectfully, I actually contacted the public access counselor and spoke with Sarah Pratt. She indicates that, first of all, the election code, as you noted, has a specific requirement that the rules be adopted and that they're not a final action. Also, that the Open Meetings Act, Section 2.02C, only requires that the agenda contain a notation of any final action to be taken on resolutions or ordinances, of which these are neither. So I believe it's appropriate and proper to have them, the initial step be the approval of the rules as required by the election.
You don't think it has to be on the agenda?
No one, nor does the public access council.
Well, to be honest, it would be, I think Mr. Ivey and I don't want to speak for Mr. Ivey. Since it takes about 5 seconds to add a line to the call to adopt the rules, to make it clean, I agree with the people who have spoken. It doesn't, I've seen it on other electoral board things, let's keep it clean, put the rules on there,
It's
we're
up to
gonna
the
do
board
it
if they-
forward anyway, we're gonna adopt new rules.
While not required, you may if you wish. It's up to the clerk and who's required to issue the call, whether or not it's on there. I would note that it's a necessary intermediate step and that the Open Meetings Act does not require that, but it's up to the board, the clerk, if she wishes to.
Thank you. We'll take that under advisement.
So the 17th at 1:30
Yes.
was what I heard?
Yes.
Okay, so is there a motion to
Yep.
recess till that
Yep.
time?
Motion to recess until Wednesday, June 17th at 1:30.
Second,
Please take the roll.
Treasurer Brophy,
Aye.
Clerk Lawrence Taylor Curry.
Aye.